Welcome to this Oakland Sunshine training by the Public Ethics Commission on public information. This training is intended for city staff and designated public records liaisons responsible for responding to public records requests. Our duty is to serve the public and to accommodate those who wish to obtain information about or participate in the decision-making process. The purpose of the Sunshine Ordinance is to clarify and supplement the California Public Records Act. The California Public Records Act is a state law that regulates public records requests, among other governmental ethics and transparency rules. The Sunshine Ordinance also assures that the people of the City of Oakland can be fully informed and thereby retain control over the instruments of local government in their city. Release of oral public information. Every department must designate a person or persons knowledgeable about the affairs of the respective agency or department. It is the duty of every designated person or persons to provide information on a timely and responsive basis. A department's designated person must be filed with the city clerk and posted online. It is also the duty of the designated person to assist members of the public in identifying any public records that they wish to obtain. The release of public records by a local body or by any agency or department is governed by the California Public Records Act and any particulars not addressed by the Sunshine Ordinance. Public Review File, Policy Body Communications. Every local body must maintain a communications file. The communications file must be organized chronologically and accessible to any person during normal business hours. The file must contain a copy of any letter, memorandum, or other writing which the clerk or secretary of such local body has distributed to or sent on behalf of a quorum of the local body concerning a matter that has been placed on the local body's agenda within the previous 30 days or is scheduled or requested to be placed on the agenda within the next 30 days. Public records requests. Any person can make a request to view or to obtain copies of a public record. Public records requests can be made orally or in writing, or a request may be submitted through the city's online public record system, Next Request. City staff should assist the requester in clarifying the request to identify specific documents or information. Providing records to the public is a public service, and staff should be proactive in helping the requester identify and find the records. For example, staff is advised to describe the information format available and physical location of the records and to provide suggestions for overcoming any practical basis for denying access to the records or information sought. Timeline for responding to a public records request. A public records request is received on the day it was submitted in person, electronically, by fax, or by phone. Staff must determine within 10 calendar days whether the record will be provided. Public records should be provided to the requester at the time staff determines that the record will be disclosed. In other words, immediately when possible. If immediate disclosure is not possible, provide an estimate in writing of when the records may be available. Records may be provided by allowing access to the documents during normal business hours or by providing an electronic or photocopy of the records to the requester, depending on the nature of the requested information. The records must be disclosed unless it falls within an exemption provided by state law. Denial of a public records request. If the record will not be disclosed, staff must promptly and within 10 days inform the requester of the decision and reasons and the statutory basis for denying the request. A denial of a public records request must be made in writing. Request for an extension. If staff cannot determine within 10 calendar days whether the record can be provided because the records are not readily available, in unusual circumstances, the initial 10-day period to make a determination may be extended up to an additional 14 days for one of the following reasons. 1. The record must be searched for and obtained from an off-site facility. 2. It involves a voluminous amount of records that must be located, gathered, and examined for possible redactions. 3. It requires consultation with another agency or among 2 or more city departments. And 4. Staff needs to compile data, write a computer program, or construct a report to extract data. If an additional 14-day extension of the determination is warranted, staff must notify the requester in writing, signed by the department director or his or her designee, that states the applicable grounds for extension and the date by which the city will make its determination. If more time is needed to determine whether the record will be provided, and there are no grounds to extend the response time for an additional 14 days, staff must seek an extension by consent of the requester and obtain the consent in writing. If some, but not all of the requested records are ready to be released, staff should disclose the documents that are ready and should release the remaining documents as soon as they become available. Immediate disclosure requests. When a city department receives an immediate disclosure request, department staff must respond within 3 business days. Immediate disclosure request has both the words immediate disclosure request written across the top of a request and only applies to public records that have been previously distributed to the public, such as past meeting agendas and agenda-related materials. The department must provide access to or a copy of the requested records immediately, but no later than 3 days unless an extension of an additional 4 days is warranted for locating or gathering the records, for a total of 7 days from the date the request was received. Staff must inform the requester in writing of the need for the extension. In no event shall any disclosable records be provided for inspection or copying any later than 14 days after the written notification by staff of when the record will be provided. Additional time shall not be permitted to delay a routine or readily answerable request. Withholding documents or information. All records must be disclosed unless they fall within an exemption allowed by the California Public Records Act. The following are categories that fall within those exemptions. 1. Personnel, medical, or similar records. 2. Preliminary notes, drafts, or memoranda. 3. Investigative records. 4. Pending claims and litigation. 5. Attorney-client privilege and attorney work product. 6. Deliberative process privilege. Some records that may be exempt under the California Public Records Act might still be publicly accessible under the Oakland Sunshine Ordinance. Even though there are common types of exemptions where a record or parts of it may be withheld from disclosure, state and local laws should be consulted along with the city attorney's office for the specific application of the exemption. Non-exempt public information. Notwithstanding any right or duty to withhold certain information under the California Public Records Act or other law, the following shall govern specific types of requests for documents and information. Drafts and memoranda. Completed preliminary drafts or memoranda are not exempt from disclosure if said completed preliminary draft or memoranda has been retained in the ordinary course of business or pursuant to law or agency or department policy. Completed preliminary drafts and memoranda concerning contracts, memoranda of understanding, or other matters subject to negotiation and pending a local body's approval need not be subject to disclosure until final action has been taken. Litigation material. Unless otherwise privileged or made confidential by law, records of all communications between a local body's representatives and the adverse party are subject to public inspection and copying, including the text and terms of any settlement agreement once the pending litigation has been settled or finally adjudicated. Personnel information. Only certain identifiable personnel information is exempt, such as home address, home telephone number, social security number, date of birth, and marital status. Job pool information, professional biographies of employees, job descriptions, gross salary, paid benefits, and memorandum of understandings are not exempt. Law enforcement information. The Oakland Police Services Agency must cooperate with all members of the public making requests for law enforcement records and documents under the California Public Records Act or other applicable law. Contracts, bids, and proposals. Contracts, contract bids, responses to requests for proposals, and all other records of communications between the city, redevelopment agency, and Board of Port Commissioners and individuals or business entities seeking contracts must be open to inspection and copying following the contract award or acceptance of a contract offer. Budget and other financial information. Any proposed or adopted budget for the city and the Port Department are non-exempt. All bills, claims, invoices, vouchers, or other records of payment obligations are also non-exempt. Redacting information. City staff must identify the information to be redacted so that non-exempt information may be released. Staff must consult with the city attorney's office for review and assistance with the legal justification. In addition, staff must explain in practical terms how the public interest would be harmed by disclosure. Minimum withholding. No record can be withheld from disclosure in its entirety unless all information contained in it is exempt from disclosure by law. Any redacted, deleted, or segregated information must include a footnote or other clear reference to the appropriate reason for withholding. Such redaction, deletion, or segregation shall be done personally by the attorney or other staff member conducting the exemption review. A withholding on the basis that disclosure is prohibited by law shall cite the applicable legal authority. A withholding on the basis that disclosure would incur civil or criminal liability shall cite any statutory or case law supporting that position. Department process. Each department director must adopt an action plan for responding to public records requests. They must also identify a public records liaison as well as an alternate. Every public records request must be entered into the public records request tracking system, Next Request. Public records liaisons, alternates, and department directors hold ultimate responsibility for ensuring that requests are logged. Although all departments have a designated public records liaison, each city employee is equally responsible for delivering records in a timely manner to the public, whether it is through a liaison or directly to an individual requesting a document, except for immediate, cost-free, readily available responses provided by staff, such as at a public-facing desk or a service counter. Communicating with the requester. Departments are encouraged to proactively provide information to the public. Departments must meet all required deadlines for providing responsive documents. If the requester has questions or concerns about their request, staff is expected to reply promptly. If there is a delay due to another department's review, staff must keep the requester informed on the timeline for release. Fees for duplication. A fee may be charged for single or multiple copies of past meeting agenda or any agenda-related materials, multiple copies of a current meeting agenda, and any other public record copied in response to a specific request. All fees must be consistent with the City of Oakland Master Fee Schedule. No fee can be charged for making public records available for inspection. No fee can be charged for a single copy of a current meeting agenda. In addition, no charge shall be made for a single copy of a draft or final environmental impact report and environmental impact statement. The agency, department, or the city may, rather than making the copies itself, contract at market rate to have a commercial copier produce the duplicates and charge the cost directly to the requester. Public records request staff support. City staff are responsible for reviewing and following the city's public records request guidelines and attending any available trainings. For help in responding to a public records request, Staff can contact the Office of the City Clerk or the Open Government Coordinator in the City Attorney's Office. Mediation Program. Any person whose request to inspect or copy public records has been denied by any local body, agency, or department may demand immediate mediation of his or her request with the Public Ethics Commission. Mediation shall commence no later than 10 days after the request for mediation is made. The local body, agency, or department shall designate a representative to participate in the mediation. Enforcement. A complaint may be filed with the Public Ethics Commission, who then may investigate and/or conduct a public hearing following investigation, may issue a cure and correct demand to a legislative body, and may file a civil lawsuit against the legislative body. Note, other civil actions can be taken by any interested party. Resources. If you have any questions about your responsibilities under Oakland's Sunshine Ordinance, you can contact the Public Ethics Commission's Advice and Assistance Line at 510-238-3593 or by email at ethicscommission@oaklandca.gov. You can also visit the Public Ethics Commission's website at www.oaklandca.gov/PEC.